Donald Trump has a victory at the Supreme Court of the United States. Democrats for a long time have really wanted his tax records. They want to get their hands on him so that they can do something with him, maybe charge him with some sort of tax fraud crimes or refer this over to the DOJ to open up some other avenue of investigation. Or maybe it's just to say he's not nearly as rich as he says he was, and so on and so forth. Who really knows? But they wanted this stuff badly, and since they're in charge of most of the government now, they have been able to get a lot of this litigation up off the ground and been able to make Trump's life pretty miserable. The House Democrats created a body called the House Ways and Means Committee. We've seen all sorts of committees in Congress where they just go after their political enemies, essentially, is really what this is boiled down to, at least in the last several years. And they have been fighting for Trump's tax records. They say the IRS has to give it to them because they are a legislative body that is properly investigating an issue, which is an outgoing president. And so we can see we've got two items that we'll take a look at here today. First, the emergency request that Donald Trump filed. You can see that is going to be the crux of this. And then we'll have a very short order that came out from the Supreme Court, Judge Roberts presiding. He is the chief judge. And because this came up through the DC Circuit, it's now going to fall on his lap. So let's start with the original filing, which was something that came from Donald Trump. You can see this here. Filed in the Supreme Court of the United States, the applicant is Donald Trump and everybody else associated with Trump. Trump's Trust, Trump Holding, all the different LLCs, along with the different corporations that Trump is involved in. Now, it's versus the United States House of Representatives. That's Congress, the Committee on Ways and Means, and the Treasury, the IRS, and all of those different agencies are responding because this is about Trump's tax records, his financial material. Now, this is on application for a stay in the Court of Appeals, the DC Circuit. Remember that because this is something taking place in Washington, Congress is saying we need this over from the IRS and the Department of Treasury, and they're fighting over this in Washington, D.C., so the D.C. Circuit Court is going to hear it, and this has already gone up through several different levels of appeals. The D.C. Circuit goes to the D.C. Circuit Court of Appeals, and they're appealing from that, which Trump lost. Remember, at the Court of Appeals, Trump actually lost. The court said, oh, yeah, you're the Congress. You can get whatever you want. By the way, this is Donald Trump. Who cares about him anyways? Just take it. And now Trump said, hold on a minute, this is not right, and made this emergency application for a stay. You see it titled here, Trump filed the emergency application for stay of the mandate pending the filing and the disposition of a petition for a writ of certiorari. And this writ of certiorari, this is the big filing, right? This is the big thing that we normally will look at on this. We'll say, wow, okay, this is the new application to the Supreme Court. It's like 120 pages. And it's a big, hefty, meaty chunk of legal paperwork that we have to read through because there's a lot that goes into it. But this is really happening quickly because, boy, that 11th Circuit or the DC Circuit just issued a ruling, Court of Appeals gave it to the government. And now Trump is saying, we have to get this done right now. So it's an emergency petition application, and you can see it's filed by several different attorneys, all listed here. As we proceed through the application, we notice that the parties to this are, of course, Donald Trump and everybody involved, along with the Committee on Ways and Means, Department of Treasury, and others. The two proceedings that took place before we got to the Supreme Court, they're saying it took place here, was in this litigation, which was decided by the DC Circuit Court, and then we see another judgment was entered on December 14th. They say there are no other related proceedings, and they're just giving us the details there. Rule 26, we have the table of contents. We're going to fast forward through all of this stuff, but you can see they give us 4-part analysis, 4 different paragraphs, arguing that the government is entitled, that Trump is entitled to a stay. Trump is demanding that the transfer of the documents of the tax records do not go from the IRS to the House Ways and Means Committee. So let's take a look. Once we fast forward through the authorities at the application, Trump's lawyers write, Dear Honorable John Roberts, Chief Justice of the Supreme Court, This case raises important questions about the separation of powers that are going to affect every future president. The only way to preserve these certiorari-worthy questions, meaning that we can get to you, Supreme Court, and you'll actually listen to us, and to avoid causing applicants like Trump irreparable harm, is for this court to grant an administrative stay by Wednesday, November 2nd. That's 1 day away from today. And guess what? They got it. Supreme Court did grant the stay, which we'll take a look at shortly. And then to stay the issuance of the mandate pending the filing and the disposition of a petition for a writ of certiorari. They're saying, Judge, we need you to just temporarily put this in place because we are putting together this whopper that we're going to send in that's going to give a lot more meat to the bones of our argument. If the court wishes, it could also alternatively construe the application as a petition for a certiorari and grant review. In other words, if you're not going to grant this immediate stay, then just consider this our whole application. They're asking for kind of the same outcome. They're giving the court two different roads to get there. They write, the House Committee on Ways and Means, through its chairman, Richard Neal, representative, has requested from the IRS 6 years of tax returns and related files for President Trump and 8 of his business entities. It's a lot of records. As justification for these records and these papers alone, the Democratic committee has offered only an interest in studying the staffing and the funding of the IRS audit process for presidents and vice presidents. So they're just like curious. Oh, I wonder what it's like to go and investigate a president. Well, we're just curious about the audit process. Yeah, right. This case is about whether that bare statement alone as a matter of law, and even in the face of extensive evidence of pretext, satisfies the test that this court, meaning you people, announced in a previous case, Trump versus Mazars. And remember, this case was back in 2020. So not that long ago. Trump's lawyers are saying, Judge, we've already had to settle this issue back in 2020. Let's continue. Trump's lawyers say, the Democratic committee's purpose in requesting Trump's tax returns has nothing to do with funding or staffing issues at the IRS, and everything to do with releasing the president's tax information to the public. Business entities aren't even the subject of the program of the committee's professed concern, nor were the requested individual returns from years outside of Trump's tenure in office. And although every president and vice president since 1977 has been subject to the presidential audit program, see Appendix 3, the committee sought records related to a single individual, Trump. That's weird. It's like they're singling him out. Oh. Trump says, on top of this objective mismatch, Chairman Neal and Speaker Pelosi in their on-the-record statements, as well as statements by other officials involved in making the request, evince quite a different purpose: exposing Trump's tax information to the public just for the sake of exposure. In other words, there's no basis for this at all. They say they need this because they're legislators. And what do they do in Congress? Well, they study issues and they bring in a bunch of people in front of committees and they put them around a round table and they pretend to ask them questions that some poor intern drafted up for them, and they put it in a big fat binder so that these bureaucrats can just read from them. And so that's what they're doing. They're saying, well, we need to investigate presidential tax implications. And so why don't we start with Trump? That sounds good. A panel of the D.C. Circuit, Trump's lawyers say, however, held that all evidence of pretext, meaning an excuse, right? In criminal law, we talk about pretextual stops. This is when a police officer stops you for basically a BS reason in order to find a bigger crime. So they'll stop you for a broken taillight. Oh, you got a broken taillight. It happens to be 2 a.m. and you happen to be leaving this area where there are drugs being sold. And so I'm just going to go ahead and stop you for a taillight, knowing that they're going to go and it's going to be used as a pretext to get into your car and find a bunch of other stuff. And so you might agree with that or disagree with that. I happen to disagree with that, but it's something that exists. Police just make up stuff all the time. I digress. They say that all of the evidence of pretext, which the district court called impressive and troubling, is insulated from review. Okay, so this means that if the Democratic committee actually wants to get Trump's record, just like a police officer might actually want to get a drug crime or actually arrest somebody for transporting narcotics, they'll say, well, we're just going to stop you for that taillight, but it's going to get us a much bigger fish. Same thing here. They're saying, oh, no, we don't want Trump's records. We just are looking at audit procedures. Yeah. For, presidents. Yeah, that makes sense. Totally benign, totally inconsequential. Nobody even cares about it. But it allows them to use that as an excuse to go do whatever the hell they want. And the district court said, well, yeah, I mean, it is impressive. Like, you are kind of skirting that one pretty nicely. It's also troubling, but it is insulated from review. The panel at the other court concluded that the bare statement of purpose on the face of the request satisfies the test announced previously by the Supreme Court. If they put in there in the statement, they say it's for a legislative purpose, then they can get whatever they want. We're Congress. We said we're doing it for a good reason, okay? So just let us do that. And of course, the D.C. Circuit Court said, yeah, let them. Trump's lawyers say there is extensive evidence that this stated purpose was only a pretext. And they're saying, Supreme Court, you said that's a problem because you can't just do stuff on pretextual bases. Trump's lawyers argue this error will hamstring the president in disputes over any future demands for information. And if allowed to stand, it will undermine the separation of powers and render the office of the presidency vulnerable to invasive information demands from political opponents in the legislative branch. Review is of the utmost importance, and the court should preserve its ability to grant it, not just for one, quote, particular president, but also for the presidency itself. Which is absolutely true. Just apply the same standard to any Democratic president. Wouldn't it be insane if a Republican committee could just go in there and just say, well, we can do whatever we want and demand anything that we want if we just, with the stroke of a pen, say that we can do that. It's a legislative purpose, right? That would be nuts. And honestly, the Republicans, if this stands, right, can and should do the exact same thing to the Democrats. Even though I may disagree with the tactic, if the Democrats are doing it, Republicans got to do it as well. It's for the sake of their survival. And so what they're arguing here is this is going to really shatter how all of this works. You better accept this because it's not just about this particular President Trump. It's about the entire institution. Trump's lawyers say the court will only have a chance to consider granting review if it stays the lower court. If it doesn't stay the lower court, guess what happens? The tax records get transferred and this whole issue becomes moot. The government has said it's going to release the requested information to the committee without delay when the mandate issues, currently scheduled for Thursday, November 3rd. So Trump's lawyers are saying, look, Judge, I mean, like it's got to be Wednesday, Tuesday, or just forget it. Because the government is scrambling. You've got a bunch of people over there at the Department of Treasury that said, holy crap, the D.C. Circuit just gave us this opening. They parted the legal seas. We better run through it before it closes up and swallows us whole. And Trump's lawyers are saying, Judge, you better do something about this because it's going to be too late. Applicants sought a stay below while the committee, meaning Trump wanted you to put a hold on this, while the committee sought an immediate issuance of the mandate to moot the case on the spot because they are snakes. They're trying to get it through before Trump can appeal it. They go, holy moly, if the Supreme Court stops this thing, we can't get him out. But if they can just eke it out, that's why John Roberts, and this was filed on Monday. The order came out on Monday. John Roberts said, stayed, you got it. The Court of Appeals denied both motions. The committee now opposes a stay of any length because they want those to leak out, including an administrative stay. The Department of Justice and the government, they oppose a stay pending certiorari, but takes no position on an administrative stay. Now, they give us a little detail on the lower opinions and the jurisdiction. And we've covered most of that. But let's get into the background and the procedural history. Trump's lawyers write, Democrats made a national issue of Trump's tax returns, And they did that back in 2016. And for the 2 years before he became chairman of the Ways and Means Committee, then ranking member Neal sought to expose Trump's tax returns to the public without offering any legislative purpose. To the contrary, Neal openly stated that he wanted to disclose the tax returns, quote, to enable the media to sift and sort them. And so the public could see whether he uses tax shelters, loopholes, and other special interest provisions to his advantage. Cited. And those are quotes. In a published report, Neal wrote that, quote, the public needed to see Trump's returns to get the clearest picture of how much he earns, how much tax he pays, his sources of income, whether he makes charitable contributions, whether he uses tax shelters, loopholes, or other special interest provisions. That doesn't really sound like it's about a legislative purpose, more so than it is about skewering Donald Trump. It's not about an overarching program of presidents. This guy hates Trump. He's got TDS with the rest of them. Minority Leader Pelosi, quote, called it one of the first things that the Democratic majority would do. And Neal affirmed that Democrats would, quote, force disclosures, saying that Democrats had voted again and again to release those documents. They hate the guy. They just want to take him out. Democrats took control of the House in 2019. Chairman Neal did not disavow his purpose, but he warned his Democratic colleagues not to step on their tongues to avoid undermining their case. When this moved forward, Speaker Pelosi, who approved Chairman Neal's ultimate request, said, quote, I think that overwhelmingly the public wants to see Trump's taxes. They want to know the truth, and they want to know the fact and that he has nothing to hide, is what Pelosi said. Spokesman for Pelosi later told the press, quote, all roads lead back to Trump's tax returns, which would show his improprieties, potential tax evasion, and violations of the Constitution. It's about Trump. It's not about audits. It's not about IRS procedures or how they audit outgoing officials. In April 2019, Chairman Neal formally requested the tax returns of Trump and 8 Trump entities, along with audit information and IRS records. Chairman Neal claimed that he needed these materials, Chairman Neal said, to study the extent to which IRS audits and enforces of the federal tax laws against the president are conducted under the manual and mandatory examination of the IRS manual. But we also see that another representative named Pascrell explained that Neal's rationale was chosen according to counsel as the best way to make sure we got the returns. Okay, so in other words, this guy just took this sort of strategy to his lawyers, and his lawyers said, well, we can't make it about Trump. We have to really expand this to make it about audits in general. And then that's going to suffice. That's going to meet that legislative purpose, and that's all we need. Chairman Neal himself acknowledged that he had strategically, quote, constructed the best possible case to stand up in court. His words, not ours. Saying, we're going to do everything we can. Okay, it's a bunch of cops waiting around to entrap you and then using justification in order to get what they want. They're just saying, well, we're on Congress. I mean, we can think about laws for whatever. And Trump happens to be in the purview of this hula hoop. Trump's team says, indeed, in the 3 years of demanding disclosure of President Trump's tax returns up to that point, he had never once offered the IRS's mandatory audit process as a rationale. Okay, so this guy says, it's about Trump, it's about Trump, it's about Trump, it's about Trump. The Democrats win in Congress. Suddenly, it's about an audit. Oh, I guess I can't really go after Trump, so we'll just make it about an audit. Isn't that convenient? As a supposed attempt to study the presidential audit program, the committee's request was far off target. Trump was not subject to that program for half of the tax years in the initial request, and none of the business entities in the request have been. The request also purported to study a program that has covered every president and vice president since 1977 by requesting information related to a single individual. Interesting. Yeah. They're studying all these presidents back to the 1970s, but they don't need any records for them. They only need Trump's. It called for files from audits that were still ongoing, and it called for the underlying tax return information, which has no relevance to a legislative study of an auditing process. right? Auditing process means we're talking about the process, not about the material. Meanwhile, committee members like Neal repeatedly contradicted their requested stated purpose. They continued to describe the requested purpose in terms of exposing Trump. It's not about passing good laws, it's about exposing the president. Saying a proper request would allow us to do our job. And to any extent that they discussed the IRS audit process, they did so in law enforcement terms, expressing their desire to audit President Trump and uncover evidence of illegal conduct. They're turning this, just like the J6 committee, into a pseudo-judicial or prosecutorial body where they can now say that we're going to use our legislative power not to go study the law or study the situation and pass laws, but to go and expose their political opponents. Now, the J6 committee was illegally constituted, still is in my opinion, and it is obviously partisan and political. It was set up for that. This is just an ordinary committee that is just ordinarily running, the House Ways and Means Committee. It's not going to expire. It's not going to sunset. This is just what they do. And you can see that according to Trump's team, they're saying that they have gone, and it's pretty good evidence here, it's their own statements. A press release issued the same day, Chairman Neal said that the request would help the committee determine whether President Trump is complying with the tax laws, right? That's kind of what a prosecutor does. You have a police, they go investigate a crime, they turn it to a prosecutor as their probable cause. Yes, you charge them. That's the executive branch. You don't have Congress running around investigating people to determine whether they comply with the law. That is clear separation of power, but these Democrats are using this language in their own House committees. And throughout 2019 and 2020, Representative Pascrell and other committee members continued to say that the committee needed Trump's tax information, quote, to see how far his crimes go. Probably a quote on MSNBC or something like that. We got to see how far his crimes go. That's not your job, Representative Pascrell. You're a representative. You're not a prosecutor. We know that you think you might be and that you're using this to fundraise and to continue to win your district. But you're a legislator. This is for the DOJ and the IRS. If Trump violated the tax laws, that's on them, not on you. The committee's improper purpose, they say, was not lost on the executive branch. And if we rewind the clock back to our social studies and civics classes, we remember that we have the three branches of government and they're co-equal, and that the three branches are supposed to, when another branch is encroaching on their territory, they're supposed to elbow them back over the line and say, that's our responsibility. We have that power, not you. So if Congress is acting like the DOJ, the Department of Justice, which resides under the executive branch, if Congress acts like the law enforcement agency that goes and polices all of America, including conveniently their political enemies, isn't that a little bit of a problem? And shouldn't the executive branch tell them, get back to your side of the line here? We have the FBI, we have the IRS, we are the executor of the law. That's why we're the executive branch, and leave us alone. But the executive branch has not done that. They have been totally willing to acquiesce to the legislative branch, and the legislative branch knows that they're working in collusion, in cahoots with the executive branch to violate all of these norms. So they don't care if there's a separation of powers problem because they have more power if they're unified. And they can create these pseudo-prosecutorial committees to go after their political opponents, and the emasculated Republican Party will just sit there and not do anything about it. And they know it. That's why they've been doing what they've been doing. So Trump's lawyers say the committee's improper purpose was not lost on the executive branch. Treasury rejected the committee's request as having an illegitimate purpose in May. It noted that the request was the culmination of a long-running, well-documented effort to expose Trump's tax returns for the sake of exposure. Treasury, this is the executive branch now, they're pushing back on this for now. They say Treasury highlighted the widespread contemporaneous acknowledgement of the committee chairman and other members of the committee, saying that the actual objective is to use the IRS as a means to expose the tax returns. Now, collecting over 40 pages of public statements, Treasury told Chairman Neal that his stated purpose was, quote, at odds with what you and many others have repeatedly said, which your intent is to publicly release Trump's tax records. Treasury, which is, this is interesting. Treasury actually pushed back on the committee and they said there is an objective mismatch, even though the district court said that it was totally legitimate. Treasury, this is wild. You've got the executive branch, which is the Treasury Department. You've got the judicial branch, which is, of course, the courts. And you have the legislative branch, and they're all stepping all over each other here. The legislative branch says we have the power to do this. The executive branch says, no, you kind of really don't. That's the Department of Treasury. And then you have the DC Circuit saying, yes, Congress, you do. Now it's going up to the Supreme Court. Treasury says that they wanted files from ongoing audits, and they focused on a single president, even though most of the requested categories have never been publicly released with respect to any president. So they're filing, we want everything. We want all the documents, everything from beginning to end. Don't even think twice, just give us everything. And Treasury says, we've never given you that before. We didn't give you that for Clinton or Obama or anybody. And now you want all of that? And you're doing it for a legislative purpose? Okay, you liars. We have 40 pages of materials that say otherwise. Treasury further noted that the request does not inquire about the IRS procedures for presidential audits. And it doesn't ask for additional information about whether they've changed over times or anything. So accordingly, Treasury determined that it's not authorized to fulfill the committee's request. And the DOJ reached the same conclusion. So you can see that. Well, now that is back in 2020. That's before the DOJ. All this has changed now. The DOJ has changed into the Biden people now. In a June 2019 memo, the Office of Legal Counsel concluded that the request represents a culmination of sustained effort for more than 2 years to get those documents. The Office of Legal Counsel found that the committee's stated purpose blinks reality. It's pretextual. No one could reasonably believe that the committee seeks 6 years of a single president's tax returns because of a newly discovered interest in legislating on the presidential audit process. Yeah, very convenient. It further noted that back through 2017 and 18, Chairman Neal and others offered many different justifications for these actions, but never oversight is what they said. They made clear their intent to acquire Trump's tax returns, and they concluded that those were not appropriate. Many of the requested documents were barely relevant to the audit process, and they were perfectly tailored to expose Trump's tax returns. That's all they wanted. But then we fast forward a little bit now. We get to July 2019. Committee sues Treasury and other government defendants to enforce its requests. Okay, so the people who are in charge right now, I sort of crisscross timeline. So let me just back up. I was crisscrossing timelines when I was ranting about the Biden administration and the DOJ and the FBI and the executive branch colluding with the Congress. That rant is not applicable yet. Right now in the timeline, we're still talking about July. Trump is still in office. It's still the Trump DOJ. It's still the Trump Department of Treasury. And none of that has changed yet. But the committee is the Democrats. They're in charge of Congress in July 2019. And so you can see now, right, until the balance of power shifted, we had the committee was not getting what it wanted. Treasury said no. This is ridiculous. You just want Trump's stuff. Same with the DOJ. Obviously, they're Trump executive branches. This is the separation of powers where you have both co-equal branches pushing back. So you don't get that stuff. But when the Democrats really, really wanted it, they sued. July 2019, they sued Treasury and other government defendants to get those records. That case was stayed pending resolution of another case, and it remained stayed for 6 months after Joe Biden took office. The new administration said, well, we have to figure out how we want to respond to all this. In July 2021, the government reversed course. Did anything happen? Did anything happen between July 2019 and July 2021 that would have caused the government to reverse course, right? In July 2019, Department of Treasury says, this is an overbroad, ridiculous request. We're not giving it to you. Same with the DOJ. It says this is a separation of powers issues. We're not giving it to you. You guys are insane partisan hacks. Get out of here. But Biden takes over. Now it's the Biden DOJ. Now it is the Biden FBI. It's the Biden executive that is okay with handing this stuff over because they don't care about the separation of powers because they're on the same team. The government reversed course. Biden's president. It informed the district court and the applicants that Chairman Neal had updated his request for Trump's tax returns. Yeah, he wanted the same information from the earlier years, and since he resent it over, Trump's not in charge anymore. Guess what? The government said, we'll comply. They said, sure. Yeah, no problem at all. We'd love to give you those records. We can't believe it took you this long to ask. In fact, we're compiling them right now for you. Thanks for bringing it up. The government then revealed a brand new OLC opinion, a new Office of Legal Counsel opinion. It just changes. Can you believe these stinking lawyers out there? Ridiculous. Suddenly, new lawyers, Biden's lawyers, they look at this thing and they say, well, that prior opinion was entirely wrong, contradicting its 2019 opinion. The new 2021 opinion did not deny the committee's long campaign to expose President Trump's tax returns to the public or retract its previous conclusions. Instead, it simply concluded that despite all evidence, Treasury had to accept the committee's stated purpose at face value, right? Treasury has no choice but to disagree with what the legislative branch said. If the legislative branch says for 20 years they hate Trump and they want to see him fall off his roof, and then on that last day they say, and also we're studying rooftops, that's all they need. They go, oh, well, they're studying rooftops. So that's all the evidence they need. Some lawyer in the Biden administration came out and said, perfect. That's it. Now, the Treasury just has to accept it. That's their new policy. Okay. And perhaps thinking the case was over, Pelosi candidly celebrated the government's reversal. Pelosi came out, she's like, yeah, not because the House could now study the presidential audit program, right? She didn't come out here and say, finally, we're going to get to the bottom of this. You know, we've had a very difficult time auditing all of these presidents. And now that we're in charge, we're going to fix the border. We're going to fix the economy. We're going to fix inflation. We're going to solve that. We're also going to solve presidential audits because holy moly, it's like herding cats with these guys. No, she didn't say any of that. Instead, she said, quote, the American people would now, quote, know the facts about President Trump. Oh. Applicants, meaning Trump, immediately answered the committee's original complaint and filed counterclaims and cross-claims. And now they're suing each other or filing claims against each other all over the place. In its ruling, the district court, the lower-level D.C. Circuit, they recounted Chairman Neal's statements. And they concluded, they said, yeah, I mean, they're relevant. Yeah, I mean, what he said about going after them, yeah, they're relevant. And yeah, they do undermine the alleged purpose. And yeah, there is evidence that is improper, that is impressive, and yeah, it is troubling. But they say that the allegations of an invalid purpose should survive on the motions to dismiss. The district court dismissed all of Trump's claims, and the district court declined to apply this court's test and instead used a different standard. Okay, some legal things here we've talked about, Nixon versus GSA. And the district court said that they only need to state, see this here, a valid legislative purpose. So if they want Trump to fall off the roof, if they say, we'd love to see him fall off the roof, I can't wait to it, snow is going to happen and America needs to see it, blah, blah, blah. But we're studying rooftops. As long as they stated that, there's a valid legislative purpose and they're good. DC Circuit says that's it. Perfect. Trump appeals, goes up to the DC Circuit Court of Appeals. Guess what? They affirmed. Yeah. They said, yeah, no, that sounds right. That sounds perfect. If they just say anything, it's good enough for us. Unlike the district court, however, the panel purported to apply the Mazars test, which is the test that the Supreme Court issued earlier. Nevertheless, it agreed with the district court that it was required to ignore all of Trump's allegations establishing an invalid purpose, saying that it could only consider the purpose that Congress identified in the request itself. We sort of talk about the four corners of a document in the law, four corners of this box. So they're saying that there's four corners here. If Congress writes the implied reason right in that box, and they submit it. We can only look within the four corners of the box. Trump says that's ridiculous, okay, because they're a bunch of liars, and everything outside of the box has said that they want to come after me personally in order to expose me and allow the American people to see this, that, or the other, and all of the other pretextual or all of the other actual reasons. The pretext is the audit. With this highly deferential review, the panel accepted Congress's, quote, need for this information without regard for other sources, rather than enforce Mazars' demand that a request be no broader than reasonably necessary to support Congress's legislative objective. The panel did not analyze the request's sprawling breadth. So what we're talking about here is a relationship between what Congress is demanding and asking for and the legislative purpose of Congress. Okay, so in this case, they wanted everything. They're making the argument. They wanted 6 years of returns and audit files. They wanted business returns, which are not even subject to presidential audits. They didn't even give us any guarantees of confidentiality of anything. Instead, they demanded detailed and substantial evidence. They ignored Trump's evidence of pretext, and they didn't assess the burdens imposed by the request at all. So the lower court didn't actually follow the test that was established by the United States Supreme Court. Supreme Court came out in a prior case, the Mazars case, and they said these things have to be correlated. You can't just go and ask for everything you want. You don't get a giant menu and you say, I'll take one of everything. No. If you want that, you need to show a direct correlation between why you need that bit of information and what you're going to do with it legislatively. And it should be no broader than reasonably necessary to support Congress's legislative objective. But they didn't do that. And the Supreme Court is saying, or Trump's lawyers are arguing to the Supreme Court that the Court of Appeals didn't follow those rules. They say, hey, Supreme Court, you said it's got to be reasonably necessary and connected. They didn't do that. They just said, well, if it's in the four corners of the box, it's good enough for us. They didn't look at the breadth of the request or how expansive it was. They didn't consider the burden at all. They just said that the request was only tolerably inconvenient and a possible but not a substantial threat to relations between the political branches. Trump's team says the panel thus reduced Mazars' scrutiny of the legislative purpose to a magic words test. Outstanding. Love that. A magic words test. Approving the request so long as the committee mouthed some permissible justification. Beautiful. Beautiful. Love that. Woo. Love that. The magic words test. IRS audit. Is that good enough? Does that work? You got it. Yeah, bingo. You got it. Bingo. IRS audit. Perfect. You get all of Trump's tax records. Congratulations. Yeah. Magic words tests. And so now you'll see that was the facts in the background. That was some of the procedural history. The rest of this is going to be some heavy lifting, which we always like to sort of really skim through. Reasons for granting the stay. We know that there are certain rules that courts have to sort of jump through. Does this apply? Yes. Does this apply? Yes. Does this apply? No. Therefore, no. And in order for the Supreme Court to grant a stay, which is to stop the IRS, stop the Department of Treasury from transferring these materials over to the House Ways and Means Committee. And as we saw previously, they want this to happen like now, right? They want all of this to be transferred very quickly. And so they're going through this. They're saying, look, Judge, there's a reasonable probability that 4 justices are going to consider this issue sufficiently meritorious to grant certiorari. Okay, so at least 4 of you people on the Supreme Court, when you hear the rest of this, you're probably going to want to hear this case. Therefore, you should grant a stay right now because it's likely that you're going to hear from us again. A fair prospect of this court is going to vote to reverse the judgment below, saying it's a 6-3 court. Probably likely you're going to reverse this underling court. And there's also a likelihood that, Judge, if you don't reverse this, there's going to be irreparable harm to Trump, which is accurate because his records will ultimately be released, right? That is exactly what they've been threatening to do. The Court of Appeals gave him permission and they say, we're going to do that. So, Judge, if you don't do these things, it's going to be a big problem. In close cases, please balance the equities, weigh the relative harms, and let us know what you'd like to do. They say the court should enter an administrative stay pending the disposition of the case. And they give us some more details and they flesh out each one of those bullet points with, you can see a lot of heavy legal lifting. A lot of this stuff, when you see a bunch of parentheticals and a bunch of italicized and a bunch of quotes and id, we're just going through case law, and they're just sort of showing the court their authority and why it applies. And so as we fast forward through the rest of the case law, let's take a look at the conclusion before we wrap it up here. It says that, well, we're still going here. And nearing the end of this, let's get to the concluding paragraphs. We're talking about equities. They say that the public has a strong interest in avoiding the dangers of intrusion between the branches. If one branch is allowed to intrude on the other branch, there are problems. And so accordingly, Trump's defense and his application to the Supreme Court lawyers, they argue, they say, we respectfully request the Supreme Court enter in an administrative stay that is granted pending the filing and the disposition of a full petition for a writ of certiorari, or else consider this to be the petition, drafted and respectfully submitted by William S. Convoy and Patrick Strawbridge, lawyers out of Arlington, Virginia. Submitted into the United States Supreme Court, landing on the desk of John Roberts, the chief judge. John Roberts grants Donald Trump's request for a stay. You see a very short order coming out of the Supreme Court of the United States. Donald Trump versus the Committee on the House Ways and Means over there in the House of Representatives. Trump submitted a big motion. He said, this is going to be a big problem, Judge. Please do not allow the IRS and the Department of Treasury to reverse course, shatter the separation of powers, and transfer my tax documents over to a partisan hack committee of Democrats. It would be a big problem if you did that. And Judge Roberts, the chief judge, ordered as follows. Upon consideration of the application of counsel for the applicants, meaning Trump, it is ordered that the mandate of the United States Court of Appeals for the District of Columbia Circuit is hereby stayed, pending further order of the undersigned, meaning me, Judge Roberts, or of the court. It is further ordered that a response to the application be filed on or before Thursday, November 10th by noon. So you can see something very interesting is happening there. That's going to be after the election. Curious. So it doesn't seem like they're going to get those records over to the committee before the election takes place. Oh man, they must be so mad right now. They almost got it in, just barely. But no, it's going to be pushed out until after the election. Oh man, they must be so upset. Isn't that just the worst? But that is the order from the Supreme Court. John Roberts is going to be awaiting the response by the U.S. government, and they're going to fight hard to continue to send those records over to the Democrats. But by the time it all happens, the election may be over. And if the Supreme Court moves quickly, well, one outcome may be that records don't ever get transferred. The other would be maybe they do get transferred. But the question is, do they have the time before the balance of power changes and the Republicans take over the House Ways and Means Committee? We, of course, will continue to follow. I hope you join us on that journey as we do. Don't forget to subscribe wherever it is you're watching this. And of course, thank you for liking this video and joining us on our next segment.